Good afternoon, everyone. This is Caroline Fraker at MedBen. We are about to start the second in our series of webinars regarding the Affordable Care Act and some things that employers need to do. Today we're going to spend about 20 minutes or so talking about the topic, and then we'll open it up to any questions that you all may have. Again, we're going to talk about whether or not you're an applicable large employer under the Affordable Care Act, and it's important to understand this because if you are a large employer, meaning you have more than 50 employees, and we'll go through how you count those employees, if you are a large employer, then you are subject to the employer penalties, and you have to jump through certain hoops with regards to the type of coverage you offer and to whom you offer it. If you are not a large employer, then you don't have to worry about all of that, excuse me, all of that, the penalties, certain types of coverage. You can continue to offer coverage to your employees as you do now, or you don't have to offer coverage without fear of penalties. Excuse me. So that's something why it's important for people to understand whether or not they're a large employer as they work through this. A couple important things to remember as we talk about the calculation and the calculation methods and time frames. There's a lot of confusion if you've been going to seminars and listening to speakers talk about the Affordable Care Act. Then you know about the look-back measurement period and counting back from the beginning of your last plan year. Those are tools that you use once you are already a large employer and subject to the offering and the penalties. When you are trying to determine whether or not you're a large employer, we use a different set of calculations and different time periods. So as people are reading and learning about the Affordable Care Act and eligibility under the Affordable Care Act, they're starting to confuse the two. I see that. I get questions on that all the time. So we're going to go through exactly how you count your employees to determine whether or not you're a large employer. And again, that's a different methodology and a different calculation tool than we use if you are already a large employer and you're trying to decide who your 30-hour employees are and who you have to offer coverage to. For this purpose, for determining whether or not you're a large employer, you use the prior calendar year in counting. You don't use the prior plan year or look back from the end of your plan year. You use the prior calendar year. So right now we're in the period of time, 2013, that we will use to make a determination as to whether or not we're a large employer in 2014, whether or not those penalties will apply to us as a large employer in 2014. So we're looking at the entire year, the entire 2013 calendar year for this determination. When we try to decide which of our employees we're going to count, we need to make sure that we're counting all of the employees of all member employers if the employer is part of a control group under Internal Revenue Code sections 414B, C, M, or O. Now, the control group rules are complicated. Whether or not you're part of a control group is really a tax determination under those sections of the Internal Revenue Code. Your accountants and actuaries should be able to help you with that determination, perhaps your legal counsel, if you are not already aware. If you have subsidiaries or have brother-sister corporations or have a parent company, it's likely that you are members of a control group. And in that case, you do have to count all of the employees of all of those affiliated employers in order to determine whether or not you have more than 50 employees and whether or not you're a large employer, or what we call an applicable large employer under the Affordable Care Act. When you also start to count employees and look at who you're counting and not counting, we use a common law definition of employee, just like we do when we are looking at the application of penalties if you are a large employer. We use the common law definition of employee. What that means is that an employee that you direct is your employee. So if you tell that person when to show up for work, and when to, what uniform to wear, and discipline that employee, and what jobs to perform when they're at your place of work, then those individuals are your common law employee. For purposes of this calculation, though, we don't use a statutory definition, which means that anyone who's a 1099 individual that you pay by a 1099 as opposed to pay by a W-2 is not counted. We don't use Fair Labor Standard definitions of employee. We use the common law definition of employee. We do get to exclude those sole proprietors, shareholders, or partners, unless those people are working also as an employee. If they're working as an employee and paid as an employee, even though they might otherwise be a shareholder or a partner of the company, you exclude them if they are only there and covered under your plan as a partner or a shareholder. We also get to exclude employees who are leased employees, those that are covered through a leasing agreement, through a temporary agency, but only those that are defined under Internal Revenue Code Section 414N, which talks specifically about leased employees, L-E-A-S-E-D, not L-E-A-S-T. All of our employees are important. None of them are leased, but leased employees, so that we can exclude them from this definition, where it is unclear right now whether we can exclude leased employees when we are talking about the penalties if we are a large employer. So these are sort of the things to bear in mind as we look at who we are going to count and start counting. When we look at counting employees, we count all of the employees. We count them differently depending on whether they're full-time or part-time, and we'll go into that in a minute. But unlike the calculations and the look-back measurement period where we're counting people and are concerned about people who work 30 hours or more, to determine whether or not you're a large employer under the law and therefore subject to the penalties, you count every single employee, no matter how many hours they work. But we count them differently, if they are full-time employees, meaning they work 30 hours or more on average, or if they're considered part-time and work less than that. And so we're going to go through that. How do I count specifically all of these people to determine whether or not I get up over that 50 threshold to decide whether I'm a large employer? So the first thing you do is you start with your full-time employees. Now again, for Affordable Care Act purposes, remember that's any employee who works 30 or more hours on average per week. So anybody who's working 30 hours or more a week are considered full-time employees, and for that part of the calculation, for that part of the count, you count those on a one-to-one basis. One count equals one full-time person, and you add all those people up and set it aside. And I have an example a little bit later in the presentation I'll show you of the calculation. Then you turn your attention to the part-time employees. The part-time employees are not counted on a one-to-one basis or on a one-count-to-one-body type basis. In order to count part-time employees, you're going to add up all of the hours they work, and we're going to translate that into a full-time equivalent number. So you take all the part-time people, anyone who works less than 30 hours on average, or anyone who works less than 30 hours just regularly. So any person that has a regularly scheduled job of less than 30 hours, and anyone who's working on average less than 30 hours, you add up all of the numbers of hours that those people actually worked during the prior calendar year. So for 2014, we're going to look back to this entire 2013 year time period and add up all the hours that those individuals actually worked to determine whether or not we're a large employer. Again, the counts are taken on a yearly basis, but you average them in the calculation by month. And that's something that you can see a little bit better when we get to the actual calculation in an example I've shown. Okay, so we're going to count all full-time employees on a one-to-one basis, and then we're going to take all part-time employees and add together their hours worked during all of 2013. When we talk about full-time employees, we have both hourly and salaried employees we have to take into consideration. You can, in both cases, for both hourly and salaried employees, you can just add up who is working 30 hours or more based on a number of hours worked calculation. You look at each week and each month of the prior year, and you see if they're working 30 hours or more, and if they are, then you add one in for each month. Or if it's easier, if an employee is working 130 hours in a month because their schedule sort of varies, but they end up working 130 hours in a month, then they are deemed to be full-time, and you count them as full-time individuals. So for an hourly employee, you just count up the hours they work and determine if they're over 30, and then you count one, again, on that one-to-one basis, one count for one employee. For salary, there's some options. You can, again, count, just like you did for the hourly employees. You can just count up the hours worked. Or if you have, for instance, if you have salespeople that work for variable hours, but you consider them a full-time employee, for purposes, again, when we talk about variable hour employees and penalties, that's a different calculation, so don't get confused. Because of Fair Labor Standards issues, salaried employees really only have to work 1 hour a day to be paid for 8. And so that's where we get these equivalency methods that you can use to count up salaried employees. So if you have a salesperson that worked 4 hours on one day and 12 the next, that's really 2 8-hour days for the equivalency method. You count up all of those people that worked for you in each month of the prior calendar year. Same with weeks worked, the weeks equivalency method. Those are just other options. Some of those work better in some industries than in others. But again, you can just count and see if people are working full-time. You just count up the number of full-time people working in each month. Part-time, of course, gets a little bit more complicated because we have to add up the hours that those people work as opposed to proportionate parts of people or averaging their proportionate hours against full-time. So to do that, you take each part-time employee and the hours they work, and those are added up for each month in the prior year. So you'll do that for each month of 2013. But you never give credit to any part-time employee. You never give them credit for more than 120 hours. If one month they work 121 hours and another they work 119 hours, you only put down 120 hours in the month that they may have lapsed over that number in any given month. You never credit any part-time employee more than 120 hours in any given month. Once all of the part-time employees' hours are added together for that month, you divide that total by 120, and that gives you a resulting equivalent. In that calculation, I'll show you here in a moment, you leave the fractions in by month. The fractions don't get averaged out until all of the months are added together and divided by 12. So it's easier when you see the actual example. So here's the example we're going to talk about to sort of bring this home. Let's say you're an employer, and these are the types of employees you have working for you in 2013, and you want to know whether or not you're a large employer. You have 28 full-time employees that are working 30 hours or more per week, 130 hours in a month, and you've added those up. So for that part of the calculation, you know that in each, for this assumption, in this example, the people who are employed the same number of hours every month. We'll do another example where it might change. But for this example, it's the same every month. So you put in 28 for your full-time employees for each month during 2013. Then you look to your part-time employees. And let's say in this case you have 20 part-time employees that work 25 hours a week, and you have 20 part-time employees that work 15 hours a week. And you need to translate those part-time hours into proportionate full-time employees or full-time employee equivalents. So you take the 25 hours they're working and you multiply it times the number of employees and then multiply by 4 to get a monthly average of 2,000 hours worked by those first 20-hour employees. Those first 20 employees. They work 2,000 hours, and that is divided by 120, so you get a full-time equivalency average of 16.67 that first group of part-time employees. You do the same calculation for the second group of part-time employees, and you get a full-time equivalency of 10. And so then basically what you do in your calculation is, so again, here's just a summary of that. You add up the 16.67 and the 10-hour equivalencies for your part-time people. So you see that you have 28 full-time employees and 26.67 full-time equivalent employees for each month during 2013. So here's what it looks like from a calculation perspective. You can see in the full-time employee column each month you had your 28 full-time employees. And then your full-time employee equivalents, again, that's average, the addition of the 2 part-time folks, the part-time employees that work 25 hours on average a month, and the part-time folks that worked 15, and that came up to 26.67. You add those 2 numbers together, and you get 54.67 total employees per month. Those are added up, and you'll see at the bottom that's a total of, you add up the fractions again, you leave the fractions in for each month, then you add up all the months, and you get 656.04 for the total employees per month, and you divide that by 12, and that's where you round, and you'll see that you I actually probably should have rounded up there to 55. In any event, you can see in this example that this is an applicable large employer, because even though the majority of their employees who worked full-time were just slightly over half of what they would need it to be an applicable large employer, or 28, the addition of the part-time people and the hours they worked to that equation brought the employer's total employees for this calculation purpose up to 54, 55 if you round up. So this employer, in this case, even though they had a large part-time population, would be considered an applicable large employer for Affordable Care Act purposes, and because of that would have to offer coverage to all of their employees working 30 or more hours on average per week. So what happens if you have people who work different part-time hours during the month? You would make that calculation by month in 2013 based on the actual full-time people working and the actual hours worked by the part-time people in that month. The reason I've done this example this way is because one of the things that we hear a lot here at MedBen from some of our employers who are on the cusp of being a large employer is, well, I'm going to change my eligibility for full-time and make everybody a 28-hour employee, and then I don't have to worry about it. Well, that's not exactly true. You could see in the other example, the part-time people did bring the count up to over 50. And while you may have changed those employees to a 28-hour-a-week employee and don't have to offer them coverage, you still are an applicable large employer for health care purposes. One thing that can make a difference is slightly changing the part-time hour people, the work that they do. So in this case, you'll see that the example is pretty much the same here for the first 8 months of the year. We've left everything the same. There are still 28 full-time employees, but now we have 15 part-time employees working 25 hours a week and 10 part-time employees working, 15 part-time employees working 25 hours a week and 10 part-time employees working 15 hours a week. But then in the last 4 months of the year, this employer needed to hire some additional part-time help, and they added an additional 10 part-time employees working 15 hours a week. So you'll see when we get to the calculation again that we have the 28 full-time people all year. Those were standard. But here, the calculation changed. We had dropped from 2667 to 1750 because we didn't have as many part-time employees working 25 hours. And those were added in at the end of the year. But just that little bit of a change in the number of part-time hours, see in the calculation, brings this employer down to not being subject to affordable care, to those penalties, because they are now not an applicable large employer. In fact, they only have 47 total employees for this particular purpose. So when you're looking back at your part-time employees and full-time employees for 2013, now's the time to start thinking about whether or not you're on the cusp of being a large employer and which side of the fence you want to fall on and how you might change. You know, you can make some very slight changes to pull your count down under 50 if you don't want to be considered a full-time, an applicable large employer under healthcare reform. Again, this is the period of time that we are looking at to determine whether or not you're an applicable large employer in 2014. And even though we've had a delay, and we're going to talk about that in future webinars, I think it's important to start making these calculations and understanding these, because the delay affects only some of the requirements that employers are subject to under healthcare reform and not all of them. A couple things we need to remember too as we're making this calculation and you're deciding who to add into the counts for full-time and part-time. Any hours that are worked by employees of yours that are worked outside of the United States are not considered in the calculation, so you don't have to count those in. There's still some open questions about successor or predecessor employees. So if you were an employer that sold or bought a business in the middle of 2013, we're still waiting on some additional information. So the IRS has said that we can use the current IRS definitions of successor and predecessor employers when we're determining employer size, particularly if you are part of a control group and you're bringing other subsidiaries or affiliates in or selling them off. You can look to the current IRS definition of successor and predecessor employer to determine if those employees need to be counted or disregarded, depending on the circumstance. In addition, if you are someone who's going to start up a company in 2013 and you want to know whether or not you'll be considered an applicable large employer in 2014, you obviously can't use the calculation we just described because you won't be able to use a full year's worth of counting. So if you started a company up at the beginning of 2014 or sometime during 2014, then you can use a just general rule that the IRS has set forth, that is, if you expect to employ at least 50 full-time employees, then you'd be considered large. If you don't, you won't. So you get the benefit of not having to count the part-time employee hours. You can just use this reasonable expectation of employing 50 full-time people. If you start a new company in 2014, then you would be subject to the law. Seasonal employees, always a big question. Again, we deal with seasonal employees differently when we're counting for the application to determine applicable large employer status versus seasonal employees for penalty purposes and coverage purposes if you already are a large employer. So seasonal employees in this case are included in your calculation unless you meet this very strict criteria, and both of these situations that are highlighted here have to exist before you could be exempt from the calculation. The first is that you have to have a workforce that actually exceeds 50 employees for less than 120 days in a calendar year. So it would be you're truly a seasonal employer. You are only operating as an employer for less than 120 days in a year with more than 50 employees. And if that's the case, then the employees who are in excess of 50 who were employed in that period can't work more than 120 days. And they have to be deemed seasonal workers under the IRS definition of seasonal worker. Very limited exclusion. If your business falls into that exclusion, then you're not an applicable large employer and you don't have to worry about complying with the penalties and offer coverage. You can use one of two determining methods for this. You can either use 4 months or 120 days, and they don't have to be consecutive. So if you could be a seasonal employer if you hired and employed people 4 months out of the year, but they aren't 4 consecutive months, as long as it isn't more than 120 days or 4 months. Again, a very limited exception, but one I think is important to understand if this is something that would apply to you. So that's the end of my general questions, my general presentation. I'll be happy to take questions. Again, because of some of the feedback issues, I would ask that you type the questions into the question box that's on your screen. So we'll give that a few minutes and see if anybody has any questions. While we're waiting to see if there are any questions, I can let you know that we are going to make these webinars available. We're looking at a couple different web options so that you can come access them at any time. For those of you who were on last week's session, the recording did have audio. It's just that some of you weren't able to hear it, so once the location of that webinar is posted, we will let you know so that you can access that and listen to the presentation in its entirety. I don't see any questions yet. I don't know what the lag time is on the questions once they're typed in. We'll give it a few more minutes here to make sure if there are any questions. We'll continue to do some research to see if we can't get the audio so that we can have interactive discussions. I don't want to unmute folks just because I'm afraid we'll have that horrible feedback issue again. Give it a couple more minutes with questions. Again, if anyone has any particular issues in making your determinations and using these calculations, you can always give me a call. I do have one question. How do you treat temporary employees? Again, temporary employees are sort of an interesting issue for this purpose alone. If you have hired them directly as temporary employees, meaning they're temporary to you, you're not hiring them on a permanent basis, but they are temporary and they're part of your workforce, then you would have to count them as part of the calculation, whether they're full-time or part-time. If you went through an employment agency and signed a contract, that's the type of employee that would be considered a leased employee. You've basically rented that employee from another employer, that professional employment organization or a PEO. If that's the case, if these are temporary employees that you've hired through a temporary agency, then for this purpose, now again, it's unclear whether or not, if you are a large employer, you're going to have to offer them coverage. But for this purpose, for counting them only, you wouldn't have to count them if you have a contract through a leasing company. But if you've just hired them as a temporary employee, then you have to count them. If you have temporary and permanent employee status at your workplace and they're hired in by you directly as a temp, then you would count them still in your look back. Maybe they don't show up for all of the months, but you would have to count the hours that they worked. An additional question, getting some questions in here. How to make this little box bigger. Okay, so can you expand on the seasonal? I think seasonal is very confusing. It's the exception to seasonal employees is really only going to apply if your business is only open for 4 months or less every year. If that's the case, then I think if you have particular questions, we can talk about those specifically. Otherwise, if you are an employer that is open and doing business and employing people 12 months out of the year or longer than 4 months, and you have some seasonal employees, then you will need to count the hours that they worked as part of this calculation. Let me use an example. Let's say you're a public employer and you have employees all year long, but you hire some seasonal people to be lifeguards at the pool or to do landscaping work or shovel snow or whatever, but you hire them just at certain times of the year and consider them seasonal. If that's the case, because you are an employer longer than 4 months during the year, you would have to count the hours that those seasonal people worked, even though they are seasonal employees. And again, that's a pretty specific requirement under this calculation of determining whether or not you're an applicable large employer, which is very different than how we would treat seasonal employees if you are a large employer and you're looking at penalties. So that's a different discussion, and we'll be talking about that in future webinars. Again, if you are hiring people through a temporary agency for this purpose, you don't have to count the hours that they work. But if they're temporary to you and you hire them directly, then you would need to count their hours. I got a sort of unrelated question, and certainly we can talk about that, and that's about whether we've gotten the official word on the delay. I keep waiting. There was supposed to be something published in the Federal Register on the 15th, which was Monday, and all we got was a Medicaid rule. We did get an official IRS notification with regards to the delay, which basically said there's going to be a delay. I don't know if we're going to get additional guidance. We're still waiting to see if they're going to put out like formal rules with regards to the delay or not. I do know that the federal government has also said, when you're talking about the delay, one of the interesting things is the delay only postponed reporting requirements that employers had to comply with in 2014. And the reason the government said that they postponed this, I saw another Treasury, actually it was Treasury testimony in front of Congress that was released this morning. The reason that the federal government said that they postponed this was because employers were not ready to do that reporting. Well, interestingly enough, they hadn't actually told us how to do that reporting. We never got a rule on that. They've also said that they will publish the rule this summer, and should employers, feel that they can comply with that, then you're free to comply early, even though there's a postponement. So we don't really have additional guidance that has been promised, at least not in the form of actual rules published through the Federal Register, there was some indication we would get that. But we do know that they are supposed to be releasing the proposed rules with regards to employer reporting. So that some of that is still up in the air. The official release did tell us that we were going to get that soon, but we just don't have it yet. We can, again, get some questions about last week's webinar. We will send out to all of the participants on the list the link to the web access for these sessions, so you can listen to these presentations as many times as you want. I say that with a smile because, I always have the boring things to talk about, but they will be there, and we will send that link out to everyone so you can access it at your leisure. I've got a question about seasonal employees. Again, if you have seasonal employees, but you are an employer that is employing people longer than 4 months, you still have to count the hours that your seasonal employees work in order to make this determination. And then I got to sort of clarify, if an employee is a temporary employee hired directly, you have to count their hours. Yeah, you have to count their hours. That doesn't mean you'll have to offer them coverage. All this is doing is determining whether or not, based on this count, you have more than 50 full-time employees. Based on actual full-time employees and part-time employee hours, you get to that total big number. And if you're up over 50, that means you have to do, well, you still don't have to offer coverage to anybody. You could pay the $2,000 penalty, which is $2,000 times every one of your employees that works 30 hours or more. Or you could avoid that penalty by offering coverage to all of those people and their dependents to age 26. But you don't, when it comes to the temporary employees and whether you're offering coverage, let's say that based on your count, you are a large employer and you hire some temporary employees. If they are yours directly and you've hired them directly, and you, not through a temporary agency, but you've hired them directly, and they work more than 30 hours, you will have to offer them coverage or be assessed the greater penalty. So it doesn't matter whether they're temporary or permanent employees. If they work more than 30 hours and they're your employees, you have to offer them coverage. There's still an outstanding question with regards to leased employees or employees that come through a temporary agency once you are a large employer. whether or not you have to offer them coverage. That's a question in the proposed rules. You don't have to offer coverage to 1099 employees, but there is a question as to whether or not you have to you have to offer coverage to leased employees who are temporary employees through a temporary agency because of this common law definition. The law says that if you're a large employer, you have to offer coverage to every common law employee working more than 30 hours. And if you use leased employees or temporary agency employees, but they come into your office and you tell them what to do and when to do it, you can fire them, you can tell them what uniform to wear, then technically they are your common law employees, and the way the law reads right now, you would have to offer them coverage unless we get additional guidance. And I think that's one of the things that the IRS is looking at. They clearly intended to not cover statutory employees, which are 1099 employees, but there's this hole as to whether or not you have to offer coverage to leased employees under the rule. So that's something to keep in mind. Getting a question about agricultural business. Again, if you are an agricultural employer, your business is open and you employ people more than 4 months out of the year, then you can't take advantage of the seasonal exception to being a large employer. You would have to count the seasonal employees and the hours worked to determine whether or not you're up over 50 or under 50. Then when you get to what you're offering and who you're offering it to, we'll still need a little bit more clarification on the rules about offering it to seasonal employees. But the way the rules now, any seasonal employee who works more than 30 hours on average a week is going to have to be offered that coverage. Now, I have some ideas about how you can work that so that those individuals may not be offered coverage until we know for sure that they've worked an average of 30 hours or more over a year. And we're going to talk about that more when we talk about the employer penalties, which is next week's session. We'll talk about employees and counting hours and so forth, but with regards to penalties and offering coverage, which is a different scenario than counting employees to determine if you're a large employer. I know it's confusing. The government couldn't, make it any easier, but you have to determine whether or not you have an agricultural business that is subject to the law. That business is open, 12 months out of the year, then anybody that they consider to be a seasonal employee will get counted. Their hours have to get counted. That seasonal employee is working more than 30 hours, they'll be counted as a full-time employee. If they're working less than 30 hours, then you, in a month, or 130 hours in a month, then you would count their part-time hours as opposed to counting them on a person-by-person basis. I've run to the end of the questions. I'm hoping this has been helpful. I will wait around and see if there are any additional questions. Apparently there is a little bit of a delay before they get typed in. I know this is complicated. I think the best way for those of you who have employers, who are an employer or are trying to advise employers that have sort of interesting employment issues, agricultural businesses, people who have seasonal employees but are open more than 4 months out of the year, those of you with large part-time populations, I'll be happy to speak one-on-one with you, and we can go through some scenarios. If you look back at the examples I showed in the calculation page, if you take those, I don't know if I can get this thing to go backwards relatively easily. Of course, I'm not going to get that. But if you do a month-by-month calculation and look at those, there's still time in the year because this is a full year calculation to determine whether or not you're large. You're not looking at, this isn't, again, a look back where you could pick 6 months or a year. You have to look at the entire 2013 plan year for 2014. And since it's July, we still have time where we might be able to affect the outcome of that calculation before 2014. And so that's an important thing. Does holiday time or vacation hours count towards hours? Yes, any paid time that you give employees counts in their hours. Unpaid time does not, but paid time does count. So when you look at your hours worked, let's say in the month of July, I worked for 3 weeks, but then I took a week of vacation. I would consider all 4 weeks as being having to be counted. So I would count the number of hours that I was eligible for under vacation in that week, plus the hours I actually worked to get to my total count. You don't take unpaid time, but you do take paid time that's allotted by the employer in the count. Great question. All right, how's everybody doing? It's a little weird because I can't see your faces, and I don't know if you're still all okay. So I always worry about my audience. We'll hang here for just a few more minutes and see if there are any additional questions. I could sing. That's not probably a very good idea. I should have like a little movie I could show in the interim, like a short. I have a few more minutes on the line if anybody wants any additional questions answered. I'm up for a song. Yay! Yeah, no, maybe not. My daughter's a singer. Okay, here's another question. Saving me and you from my singing. If an employer offers the coverage to their employees, how much of it does the employer have to pay? Okay, if you are an applicable large employer and you have to offer the coverage, and we'll go over this more next week, but you can charge whatever you want. That said, you will make your plan unaffordable if you charge more than a certain amount based on a calculation. So there are several ways sort of to think about that. From my perspective, it's always best to avoid the greater penalty. When I talk about the greater penalty, I'm talking about the penalty that would apply to you if you're an applicable large employer, meaning you have more than 50 employees, but you don't offer coverage. And if you don't offer coverage, then that penalty is $2,000 times each one of your 30 or more hour employees. So you look at how many people, in the example I showed, for instance, in the first example, I had 54 employees, so I was an applicable large employer. If I didn't offer coverage, I would have to pay, let me get my calculator going, but I had 28 people that worked more than 30 hours. So I'd have to pay $56,000 in penalties because I had 28 people who worked 30 hours or more times 2,000, which is $56,000. That would be my penalty. Now, I could offer coverage. Let's say I want to avoid that penalty, and I could offer that coverage, and I could charge them, 50% of my cost. But then what's going to end up happening is we talk about the lesser penalty, and the lesser penalty is $3,000 per person, but it's only per each person that for which the coverage you offer is considered unaffordable, and that person has gone to the exchange and gotten money from the federal government to buy coverage under the exchange. All of those things sort of have to happen for the $3,000. So while you are allowed under the law to charge whatever you want for the plan, you want to make sure that you think about what you're charging to make sure that you've met what we call minimum value. Again, a concept we're going to go over in 2 weeks quite in depth, and that it's affordable, meaning what you charge the participant for that coverage, the employee-only portion of the coverage doesn't apply to dependents, employee-only contribution is not more than 9.5% of their, it's complicated as well, the safe harbor is W-2 income, or 400% of federal poverty. technically under the law it's 9.5% of their household income, but we don't know that, so the government says you can use their W-2 income in 2014. Again, we'll go over this in more detail next week, but there's nothing that prohibits you from charging what you need to charge. It just may be that it becomes affordable for some people and unaffordable for others. And those people for whom the coverage might be unaffordable based on that calculation, if they go to the exchange and they get a subsidy from the federal government to get coverage through the exchange, then you end up paying a $3,000 penalty for that person for that for having not offered affordable coverage. And again, we're going to go into that a little bit more. Okay, we have some other questions here. What are penalties? Since you brought up the penalties, the $2,000 penalties is employee only, correct? Yes. The $2,000 penalty, well, no, I take that back. The lesser penalty, the $3,000 penalty, is only for employee coverage. The $2,000 offering, in order to not have to pay the $2,000 per 30-hour employee greater penalty, you have to offer coverage to every employee and to their dependent children up to age 26. You don't have to offer coverage to spouses, but you have to offer the coverage to dependents. So if you have a plan that is only an employee-only plan, you only offer coverage to employees, even though you might be offering it to every 30-hour employee, if you don't offer to the dependents, you could still, in the example we talked about, be penalized to $56,000. The offering has to be to employees and dependents to age 26, but not spouses, in order to avoid that. When we talk about the lesser penalty, we talk about whether something's affordable or not. We are only concerned with whether it's affordable to the employee. One of the things that you could do then is you offer coverage to all employees and dependents to age 26. You make the employee-only coverage charge, the contributions that employees pay for their own coverage only, affordable. You set that contribution to meet the 9.5% rule. And then you charge dependents 100%. You could charge dependents 100% of the coverage provided to them. They could go to the exchange still and get coverage without a penalty coming back to you, because the affordability test, the lesser penalty test, only applies to employee-only coverage. Right? So that's an important thing. So you need to start looking at that, particularly if you've only ever offered employee-only coverage and you need to start offering dependent coverage to avoid that big penalty. You can pass on 100% of the cost of that contribution. One thing to remember, with the delay, even though the delay is really on the reporting requirements, because the reporting requirements were going to tell the federal government, what you reported to them was going to tell them whether or not you offered an affordable plan and what you charged for it and what your employee's income is and all of those important things, so they can decide whether or not you're meeting these rules and whether or not individuals are eligible for subsidies. Because they don't know that now, because they're not getting those reports, they've also delayed the penalties. So 2014 really becomes a test year. A lot of what we have to do with health care reform still goes forward. It isn't a full delay. It's just a delay on the reporting, and then by a consequence of that is a delay on the federal government's applying a penalty back to you. So it gives us some time to actually work through some scenarios, to work with our plans in a test environment to get them ready for 2015 without worrying about the test or the action we take failing and we still get a penalty. So I think it's important to remember that we still have things to do next year, but we do have enough of a reprieve that it allows us to do some of those things in a penalty-free environment, which I think is important right now as we move forward. So that was again the last of the current questions. We'll wait again a little bit and see if there are any more. Again, since I haven't seen any questions pop up that says that say I can't hear or what's that horrible noise, I'm assuming that the audio is going much better than last week. So we're making progress. That's good over here. Yay to our MedBen webinar team. They've been great. Okay, well, I'm going to give it about 2 more minutes, and then we will quit for the day. I do want to remind you that next week, July 25th, we're talking about shared responsibility penalties. Those are the penalties and affordability strategies. So some of the things we talked about, how do I offer a plan without being, hit if I only have employees covered now. And so we're going to talk about some of the strategies and things we can do. We'll go over, as part of that discussion, at least what we know right now about who we have to cover and how we have to cover them. The week after that, August 1st, we're going to talk about the minimum value calculator, such as it is. It's a little convoluted, and about minimum value safe harbors and how we can use those. When we talk about the lesser penalty, you'll remember that there are 2 tests that have to be passed in order to avoid that penalty. One is the minimum value test, and one is the affordability test, or the 9.5% test. And we'll talk about the minimum value issue there. And then on August 8th, we'll talk about using measurement period safe harbors to determine eligibility, whether that safe harbor is something you want to use. It's something you don't have to use, but you can, and if you want to, we'll talk about how you do that. And on August 15th, we're going to talk about exchanges in your HR department, how you go about handling employees and the questions they're going to have about the exchanges, and in particularly some of the exchange notice information we have to put out. And then by the 22nd, we're going to talk about the new wellness rules and the impact of those rules on our 2014 plans, in particular the penalties and how we work those things together. So I invite you all to those. Seeing no other questions, I think we can go ahead and terminate the seminar. I really appreciate your time, everybody. This has been great. If anybody has any additional questions, please feel free to call me directly. My contact information is on the screen. And I thank you all for joining. Have a wonderful day.